Being an executor carries significant legal responsibilities, and when it's done incorrectly, can cost you tens of thousands of dollars in legal fees, several years of your life, court cases, and worst case scenario, your family never speaking to you ever again. Yes, unfortunately, this does actually happen. So, welcome back to this free series on probate, executorship, and some of the common questions and issues that you might face on this topic. My name is Steve Parr, and I'm a business lawyer and estate planning lawyer from Vancouver, Canada, and I'm here to cover everything that you need to know about being an executor. So in the last video, we discussed some considerations in becoming an executor and the process of what happens after you become that executor. So today, I'm going to be discussing answers and solutions to common questions and problems that you might encounter as an executor. So let's jump right in and answer the first question that you might be wondering. Can you get paid to be an executor? The process usually takes 6 to 12 months, although it could take upwards of several years. It can be very stressful, so it's not unreasonable to expect some sort of compensation. In British Columbia, an executor can claim compensation. They are entitled to fair and reasonable compensation for their services. The amount may well be set out in the will. However, if the will is silent on this, then the executor will need to have the approval of the beneficiaries for what the executor wishes to claim, or to get court approval if they cannot obtain beneficiaries' approval. So the specific amount of compensation is going to be dependent upon the complexity of the estate, the amount of work that's required to administer the estate, and the value of the assets involved. Generally, however, the compensation is going to be based as a percentage of the value of the estate. So allowable amounts in British Columbia is up to 5% under the Trustee Act. An important note is that the executor cannot just pay themselves whatever they feel like, and if they do so, they are exposing themselves to lawsuits. They must seek approval from the court or beneficiaries for taking any compensation from the estate. Here's the next problem which you may run into as an executor. The beneficiaries are demanding that you provide an advance payout. Should you do it? Is there a way that you can do it and protect yourself? It's very important to carefully consider the situation and get professional advice before making any decisions. However, here are some factors that you're going to want to consider. 1. The terms of the will. There may be a provision for an advance payout or a distribution. This could support you in making an early distribution. However, such provisions are rare. If there is no provision regarding this, you would need to get permission from the court or consent from all beneficiaries before making any payments. Furthermore, if you make distributions without obtaining a CRA tax clearance certificate, then you as an executor may be personally liable for any unpaid taxes that the estate owes. Not great. And if the estate is illiquid after your early distribution, then you have a real pickle on your hands. 2. It's critical to ensure that the estate has sufficient funds to cover all debts, taxes, and expenses. If the estate is already under financial strain, making an advance payout could make things much more complicated down the line. 3rd, protect yourself. If you make an advance payout, you'll want to protect yourself from potential liability or future disputes. This could include obtaining signed releases from the beneficiaries or permission from the court to make the payout. There are also various insurance products, aptly called executor's insurance, that you may want to investigate. In general, it's recommended that you consult with a lawyer or estate planning professional on the topic. We can help you with this at Parr Business Law, so don't hesitate to reach out. So moving on, what happens if the will-appointed executor dies during the probate process? If this happens, then the court will typically appoint a new executor to complete the administration of the estate. In most cases, the will itself will name an alternative or successor executor in case the primary one is unable or unwilling to serve. Whether by pre-appointment via the will or by appointment by the court, this new executor will need to go through the same process as the original executor, including filing all the necessary paperwork, notifying the beneficiaries and creditors, and distributing the assets of the estate accordingly. For more info on executor duties, be sure to check out the last video in this series. Now, as the executor, you may have to deal with family disputes. What happens if the beneficiaries or non-beneficiaries do not agree with the distribution? Disagreements can happen for a variety of reasons, as the proposed distribution of assets, or various interpretations of the terms of the will, or even they might challenge the appointment of the executor. So if you find yourself in this situation, be aware that these types of disagreements can be complex, cause emotional stress, and will often result in lengthy and costly legal battles. You should try everything that you can to resolve this dispute amicably through negotiation and good communication. This is the first step in proceeding with the disagreement. You may wish to hire a mediator or a facilitator to help you come to an agreement. If negotiation fails, one or more beneficiaries may choose to take legal action. This could include filing a petition with the probate court, which might result in a court hearing or trial. The court would then make the final decision based on the evidence presented. In certain cases, the court may appoint a special or interim administrator to manage the estate during this dispute. This can help ensure that the estate is properly managed and that the assets are not wasted or misused during the dispute. Now, if the parties are able to reach a settlement or compromise, the court can approve the agreement and order the distribution of the assets accordingly. Here at Bar Business Law, we are able to help you with being an executor. We specialize in wills, probate, and estate planning. We're happy to help you in any way that we can. If you're interested in more free content on estate planning and business law, be sure to subscribe to the Bar Business Law YouTube channel. Thanks for watching.